Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, Jeff Roberts, welcome back. Today we're going to kind of go back into the realm of Social Security benefits, Social Security disability, supplemental security income, SSI as well. And I want to have you unpack and explore with us the impact of substance abuse on a claim or an application there, because this happens, and it's something that over the years you've bound to have seen in some clients. And let's talk about kind of how that can impact a case.
Sure. And I have certainly seen it over the years of my practice after doing this for 27 plus years now. And it does have an impact on a case when someone has a substance abuse issue, and we see it. You're seeing in society a much greater acknowledgement of substance abuse and somewhat of a more concerted effort, especially with opioid addictions and those things, to get people treatment and to help people who have substance abuse issues. So it's kind of more on the forefront as far as in the news and media outlets, but it's something that we've dealt with in Social Security disability cases for quite some time. To be honest with you, it's been there ever since I've been practicing.
And to clarify, this could be alcohol abuse, this could be marijuana use, this could be prescription drugs, this could be illicit OxyContin, stuff like that. It could be something even worse. It could be heroin or some of the other problems that we have.
Exactly. Yeah, it can be any of those substances. It can be and normally there's not a problem for people taking a prescription medication as it's prescribed. It's where they are taking more than they're supposed to be taking, or they have a prescription for hydrocodone and they're also somehow testing positive for OxyContin. And so they're getting the substances in an illicit way as well as what's being prescribed to the individual.
And when they have a situation for which they need to apply for disability, obviously there are going to be medical records, there are going to be lab draws, there are going to be all these other things. And that's typically, I guess, when some of the proof of, hey, something else is going on is showing up in the blood work, right?
Yes, exactly. A lot of states, Kentucky being one of them, in certain instances, when narcotics are being prescribed on an ongoing basis for someone, opioid pain medication or something of that nature, the prescribing doctor frequently will have the person submit to a urine test to make sure the substances are in their system, but it's only the substances that are being prescribed that are in their system. Sometimes they'll do send-off tests so they get the levels to make sure the substance is at the proper level within their system. And also they will run a Casper report, which is making sure it's anytime a narcotic prescription is, and maybe some others, but I know narcotic prescriptions are written, that is reported to the Cabinet for Families and Children, and they community-based services, I believe. I can't remember what the cabinet level name is, but anyway, they maintain that list to make sure people aren't doctor shopping and going to family doctor and getting a pain medication and then going to a pain management doctor and getting the exact same pain medication and getting basically double prescriptions,
doubling it up, tripling it up, selling something off, things
exactly.
Like that. And I guess with all of the medical records that are available, ultimately those end up in front of the judge's eyes as well. I mean, so the judge is actually going to see these reports, so it's kind of hard to hide it when it does show up.
Absolutely, yes. You're not going to hide it when it shows up in those records. And the best thing to do, at least from my perspective, is to address it head on. And I normally do that actually with the client well before we go in front of a judge. Once one of the things that I talk with a lot of my clients in the initial visit is whether they got any type of criminal history and whether they have any type of substance abuse history, because both of those can have an impact later on in the claim. And I want to make sure that I'm aware of all of that because, as we've said on other episodes, I do things on a contingency fee basis, and I don't want to have a whole lot of time invested in a case only to find out I've got a major issues that's going to cause me to lose this case down the road after I've got that time invested when my fee is based on being successful in the claim.
Oh, Jeff, I forgot to tell you about this. Yeah, the little details, right?
Yes.
I guess there's always that temptation, especially when it's dealing with pain in particular, to self-medicate, and that tends to become a problem in the case.
It certainly can.
Or at least it's a risk, I guess.
It is a risk, and it can be a problem. And I do see that with people who are in pain, especially if they aren't able to get their prescription medications for whatever reason. They may self-medicate with a street drug of some sort. And I see it, self-medication, frequently in mental health issues as well, that people who have significant mental health issues use illicit substances to basically get outside their own mind, so to speak.
Right. And now you told me as we were preparing for this episode that it doesn't necessarily mean the case is going to die on the vine. It doesn't necessarily mean it disqualifies them, but it puts a significant hurdle that you have to overcome, and that comes down to the underlying issue, right? That's being coped with. You want to explain that?
Sure. I mean, from a purely legal standpoint, what the standard essentially is that the judge is supposed to apply in these cases is: would the individual still be considered disabled if they were sober, if they weren't using any intoxicating substances, had no substance abuse problem? So if it's a person who has a severe spinal injury and paralysis that is taking too much pain medications, but if they stop using the pain medication, they're not, they're still going to have the paralysis issues and the spinal issues that they already have, and that's not the substance abuse isn't. It may mask the effects on them to some extent, but it doesn't fix the problem if they stop using the substance. And that individual under the statute should still be considered disabled because the substance abuse is not material to their disability in that situation. But and that's what the statutory standard is, and what is supposed to be applied. But at least in my viewpoint, we've talked about this briefly beforehand. I think that the attorney needs to have a real heart-to-heart conversation with their client, and I've had that heart-to-heart conversation with clients and potential clients in the past about that. And if the person does have a substance abuse issue, whether it's just a substance abuse issue or if it's a self-medication issue, to try to get them to deal with that, and get into some sort of a substance abuse treatment program, whether it be a short-term inpatient stay, a long-term inpatient stay, outpatient treatment, but try to get them off of the substances. If it's a self-medication issue, especially with mental health conditions, trying to get them into a proper mental health provider and get their appropriate mental health medications that they should be taking instead of using the substances to self-medicate. And then, if the person who does that and the judge sees, they had this problem before, but they have taken care of that problem, or they are addressing this problem and they're getting better, and they're not using those substances, that the old cliche is true, and that is, people want to help people who are trying to help themselves.
Right.
And that's the kind of the situation that you come into from that standpoint. So you can actually keep going with the case even though they have a substance abuse issue, as long as they're trying to get help. Now, if I've got somebody that comes in and they've got a significant substance abuse problem, and I have that conversation, and even if I think that I could possibly win their disability claim because of their underlying medical or mental health issues, if they have no interest in stopping their abuse of substances. And I've told people that I truly thought I could win their case, and told them that I'm not going to represent you in this case because I'm not going to be the one to get you on disability, so you can use that just to basically keep circling down the drain because of substance abuse.
And possibly end up in an overdose situation, which is obviously life-threatening at times.
Yeah, substance abuse is it has taken a lot of good people away from us.
Yeah. You made a point about the judge kind of looks at that, and people want to help people who are helping themselves. A lot of this does come down to subjectivity, and I think when a judge sees someone who's going down a bad path regarding substance abuse or substance use, you can't help but be subjective. And I think while the law says one thing, the ultimate call, the actual decision, is made by a human.
Well, exactly. And the law says, the statute is clear on what the law is, but which witnesses you wish to believe is ultimately a determination by the judge. And so in the human, our human nature comes into play in that regard. And it does with judges just the same as it does with anybody else, at least in my opinion. And, there are some judges that will say they're able to put aside some of those human nature, so to speak. I don't know that it's possible for any of us truly to do that, but they may be better humans than I am in that regard. But yes, and I think you have some judges, if the person is actively continuing to use and has no intent to stop, doesn't seem to think it's a problem whatsoever that they're doing that they're using illegal substances. I think a judge is going to look a lot closer at that evidence in that case. And just the same as I said, I've told people that I'm not going to represent them in the case. And I think the judge is going to follow the law. But if they got one doctor who says this substance is material, substance abuse is material to the disability, they're more likely to believe that doctor who's saying that than they are a doctor who's saying that it's not material. They would still be disabled even if they were sober.
Well, is there ever a relationship between the substance abuse and the problem stemming from substance? So if I'm drinking too much and suddenly I get cirrhosis of the liver, that really wasn't an issue caused somewhere else. It was caused by the drinking. So I mean, is there a relationship there that makes it harder in terms of the case or the claim?
Under the legal standards, no.
Okay.
Under the human standards, I think it does make it a little more difficult. If you have, a cirrhosis of the liver that is very severe, that's disabling to an individual, and it's one cirrhosis is because of chemical exposure at their workplace, and the other cirrhosis person is because of alcohol abuse. I think the person who has the alcohol abuse is going to have a harder time being successful in the claim. Now, from the purely legal standpoint, if their cirrhosis is at the same level and it's disabling, then technically it ought to be decided exactly the same way from there. And it comes back to, if they stop drinking, they're still going to have their cirrhosis. It's
Right.
still
So
going
the
to be at the
underlying
same
issue is still
level. So
there.
the underlying issue, even though it's caused by that, the underlying issue is there, and stopping the intake of alcohol isn't going to repair the liver, get rid of the cirrhosis from that standpoint. And you get back to what I was saying earlier. If it's someone who's actively trying to stop using those substances and going through treatment programs or going to AA or NA type meetings, then a judge may be, at least in my viewpoint, a judge is going to look at it at that more favorably than someone who is got a six pack on ice to go get a drink right after the Social Security hearing.
Right. Or before.
Yeah.
So that's always problematic.
Luckily, I've never had any show up at a hearing that have been drinking beforehand. So
now under the issue of or the topic of Social Security disability and Social Security, the SSI, the supplemental security income, are they both treated the same way relative to substance abuse? I mean, you might see SSI apply in a mental health situation. Maybe somebody's schizophrenic or somebody is bipolar and they're self-medicating, as you had alluded to earlier, versus somebody who was working and now, I mean, they're two different programs, but I guess it kind of is treated similarly?
They are treated basically the same in regard to whether someone is disabled or not. The definitions and have how someone is found disabled for Social Security disability and for supplemental security income disability are the same. It's the exact same standards from that standpoint.
Can you work the 40-hour work week and things like that?
Yes, do you meet the listings of impairment, or are there jobs out there in the national economy that you can do? In the standard for substance abuse is the same. There is the substance abuse material to the disability. Would they still be disabled even if they weren't using any type of substances? So that determination is the same. Now, the difference between the two is the non-medical requirements for SSI and for Social Security disability, which I think we've talked about before. But for Social Security disability, you have to have worked a certain amount of time and paid a certain amount into the system to be eligible to receive that. Kind of like paying insurance premiums to some extent. That's the at least the layman's way of comparing it to something that people are used to. SSI is paid out based on financial need. So if you're disabled but you got $100,000 in the bank, you're not going to get SSI benefits because you exceed the income and the resources limit. So it's a needs-based program.
And so that's significantly different. So a lot of times and we've discussed this in the past as well, that you may be able to couple a workers' compensation claim with an SSDI claim. Does substance abuse come into play on a workers' comp claim?
It certainly can, yeah. And in fact, there was a law change in 2018 that we've talked about before in other cases. One of the changes was how intoxication is dealt with. If the intoxication, before it was if the intoxication was a proximate cause of the injury, the person did not get any benefits.
So I show up drunk, I'm working a lathe, and I take a finger off.
Exactly. And if that's the case, and your being drunk is the reason you took your finger off, you didn't get anything under workers' comp for that under the old law. If you were drunk at work and somebody, you're doing your job like you're supposed to be doing it, and somebody runs over you with a forklift, you still got paid because your intoxication didn't cause your injury in that situation. And the change in the law now is basically if you are intoxicated, then on the job at the time, you don't get any benefits, even if it had absolutely nothing to do with your with your injury or your occupational disease. You don't get any benefits under it's presumed that is the cause of your injury or your disease. Now, and I used alcohol earlier, and I should
intoxication could be a substance, right?
And actually, under the new law, I don't think being drunk at work qualifies, because it says an illegal substance or a prescribed substance in excess of what it's prescribed, as established by a blood test.
So if I'm following doctor's orders in terms of the amount of tablets or whatever I'm taking, yeah, I'm okay for that.
Exactly, you're okay for that. But alcohol is not an illegal substance, so it's unknown right now. There's disagreement among attorneys on whether alcohol, being drunk at work, would actually be considered fall under the new statute or not. I don't know of any cases that are actually even testing that at this point. But the way the new statute, and I've had some defense attorneys that don't like me to point this out, but the new statute, the way it is written, if and I'm going to use a coal miner in this example, even though we don't have coal mines in the Murray, Calloway County area, but a coal miner who has a migraine one night and his wife has a prescription Lortabs, and he takes one of her Lortabs. He's not prescribed it, so it's not a prescribed substance for him. He goes into work and he starts coughing and having problems, and then they find out, they have him x-rayed, he's got black lung. They do a blood test, see that he's got the Lortab in his system that wasn't prescribed to him. under the way the law is written now, it's presumed that that one Lortab he took is the cause of his black lung disease. I think it's got constitutional issues from that, but that's the way the statute is worded.
I actually saw you present at a comp ed seminar, which is a statewide workers' comp seminar. And in your presentation, you brought that up. I think that was just last year or the year before that. And I was surprised to hear that. But as the law is written now, you guys have to contend with that.
Exactly. As the law is written now, and it was because the statute was passed in 2018, took effect July of 2018. So I think I presented in July or in May of 2019 at that comp ed seminar, or June of 2019 at the comp ed seminar on that very topic, or on the changes in the law.
Right.
So.
And things that were in flux right now, and we needed to clarify that in some manner.
Correct.
But so again, the substance abuse doesn't really seem to be. It doesn't kill the case, but from your standpoint as an attorney representing your client and moving this case through the system, it certainly adds a significant complication.
It does add a significant complication to the case, and that's where where I have that conversation at the very beginning with my client, and I will tell them, as long as they're wanting to get help, I'll try to help them not only with their Social Security case, I'll try to help them find resources to help with their substance abuse issue, and get them into that, and then document their efforts to try to get sober, to try to get clean, because that will be what I use to show the judge in the Social Security case that this person has had a substance abuse issue, and unfortunately, sometimes from the time I get hired in the Social Security case till we have a hearing in front of a judge can be a year and a half, and so it can this person had a substance abuse issue in the past, but they've been sober for a year now, or 6 months, or hopefully a year or longer. From that standpoint, and that can be very helpful in that individual case. It'd probably be better that they never had the substance abuse issue, but at least that they've gotten better and they're still having all of these issues is very helpful from that standpoint. And but if they're still using, it's very hurtful.
We think that if they're under a doctor's care for this treatment, or if they're under some kind of facility, let's say it's inpatient, or there'll be documentation available, and that's something you can enter into the case notes and as an exhibit, say, hey, look, here's proof. It's not just me standing up here, Your Honor, and saying this. It's actually, here's the documentation. And again, everybody's human, and you've got to think that that's going to play into some level into their ultimate decision whether or not to award these benefits and how that should be played out.
Certainly, and then and along those lines, I mentioned AA earlier. And Alcoholics Anonymous is a great program, and it's helped a lot of people get sober, but they don't, as I understand the program, they do not do random screens on their individuals who are going through that. So I have no problem and recommend people to go to AA, get a sponsor, and try to get sober from that standpoint. But I generally like for my clients also to go to a treatment facility or substance abuse treatment where they are doing random drug screens so I can show they are trying to be sober. They are sober. They're
taking
they're
some
staying
ownership
clean.
and accountability of it.
They're staying clean and sober, and I can establish that to the judge over just my client's word that yes, I've been sober for the last year. I've got clean drug screens for the last year showing they've been clean and sober for the last year, and that helps out from that standpoint. The other side that I've seen in this as well is it used to be judges in deciding these cases, in determining the pain level that an individual would have 5, 6, 10 years ago, one of the things they would look at was, are you taking pain medication? And if you weren't taking pain medication, I've had judges say, look, if you really hurt as bad as you say you hurt, you would be taking pain medication to get rid of it. And judges now are realizing the effects that pain medication can have on individuals on a long-term basis, and I've represented a lot of folks who, and frankly, I'm the same way. I'm going to have to be really, really, really hurting before I'm going to take any type of a narcotic pain medication. And I've got a lot of folks who will not take a narcotic pain medication because they've seen what it's done to family members or what it did to them 20 years ago.
And that risk of addiction or recurrence or relapse
exactly,
is substantial.
Exactly. And I'm not seeing now, at least I haven't in the last few years, judges penalizing an individual because they weren't taking pain medication, which I think is a positive advancement with the judges from that standpoint. I don't think they ever should have penalized somebody for not wanting to put some kind of substance like that in their body. But nowadays, I can't recall really the last time I saw a judge actually refer to that in a negative light in the decision that the person wasn't taking pain medicine, so they're not hurting as bad as they say they are, or they would be doing that. And I think that's at least a positive step.
Well, that's where I was going. That's a positive step for the system and the bureaucracy. That, hey, look, there's still some rationality in there, which is a good thing. I mean, it's always a good thing.
Right.
Jeff, this is a sensitive topic for people, especially if they are in pain and trying to cope with it and go on with life and provide or just exist. And it's a terrible situation to be in, but it's something that needs to be considered. And it sounds like, obviously, after 27 years of doing this, you've had these conversations. You know how to deal with it. You know how to coach the client to hopefully deal with it, and ultimately maybe get into a better place in life in general. And if it helps the case or helps the claim, so much the better.
Absolutely.
Fantastic. Jeff, I appreciate your time. I know you're a busy guy, and we'll be back in about 2 weeks. All the best. Take care.
Thank you.
Yep. See ya. Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.